And those folks made it very clear, we need to tell our story. So they would drop what they were doing. We knew they were coming off the road, from their own business to make their voices heard in Sacramento. And I would characterize it as probably 95% of the voices at legislative hearings and individuals testifying. Probably 95% of those individuals were from trucking, were the independent owner operators. And then you'd have some Uber and Lyft drivers here and there. You'd have some emergency room doctors, believe it or not, who were saying, we're independent contractors. We want to continue doing it. But clearly throughout the year of 2019, the voices of those independent owner operators were front and center the whole year.
The subject of this week's edition of the Overdrive Radio podcast, an exclusive look at the Supreme Court challenge that finally got off the ground this week against application of California's AB 5 contractor law to trucking, which would spell doom for owner-operators' traditional leasing models with motor carriers in that state.
So if you're a motor carrier and you're doing business with an owner-operator under a conventional independent contractor agreement where they're operating under your authority, that model is really challenged by AB 5.
I'm Overdrive editor Todd Dills, and we're going to drop into the annual Symposium event hosted by Overdrive sister fleet publication CCJ down in Birmingham, Alabama, which happened this week, bringing together individuals from carriers of all sizes for a few days' worth of talks and information sharing. No shortage of fun, too. Among speakers was the man you heard at the top, who I had a chance to talk to briefly after a roundtable on the California contractor law and his association's challenge of it.
Sure. So first name Shawn, last name Yadon, Yadon, CEO of the California Trucking Association.
Yadon was describing what he saw with his own eyes on the ground in 2019 as a groundswell of grassroots advocacy rose among owner-operators domiciled in California and leased to motor carriers. The result of that advocacy, though? A myriad of carveouts in the law by the legislature aimed at a laundry list of
insurance
professions.
agents, doctors, lawyers, architects, CPAs, engineers, commercial fishermen, newspaper distribution, newspaper carrying, photographers, professional services of all kind, IRS contractors, freelance writers, licensed cosmetologists, financial advisors, realtors, and repro men, to name a few. That's just a short list of
but not independent owner-operators. As transportation attorney Greg Fury made clear for the assembled with that laundry list there. Both men had much more to say about the history of how we got to this point, with the California Trucking Association now filing its petition to the Supreme Court and hoping they'll take the case, and owner-operators and their contracting motor carriers still playing the high-stakes waiting game on the outcome.
Empathize with, like you said, the single truck guys and gals out there. I mean, the confusion and the uncertainty of being in this kind of limbo period makes it tough for everybody. I think a lot of folks are just optimistic, saying we know this is the right thing. We know our ability to operate independently should be protected. So I think there's a lot of hopeful individuals out there that are kind of hanging their hats on this litigation, and we're certainly doing that. And we're not going to stop the fight. So we knew all roads would lead to the U.S. Supreme Court, and here we are. So again, we feel good about the filing we put forth, and we'll see if the Supreme Court does the right thing and takes it up.
While we all wait to learn that eventuality, though, Attorney Fury, you'll hear, will point to models that presumably are safe from application of the ABC independent contractor test that's codified in California's AB 5 law.
The flip side of that presumably is this, that instead of being a motor carrier, you broker the freight to that same owner-operator who's gone out and got their own motor carrier. Now the legal argument is, under the B prong, remember that's the one we're worried about, Judge, I'm in a different trade profession or occupation from the owner-operator who's a motor carrier. First of all, the motor carrier has a lot more and different regulations that they have to operate under. They have a completely different authority. I'm a broker. I actually can't move freight physically from point A to point B under a broker authority. It has to be a motor carrier authority, and a motor carrier can't broker freight under motor carrier authority. So there's some pretty compelling, albeit maybe a little technical, arguments to say Property brokerage is a different trade, occupation, or profession from motor carriage.
And Yadon's got certainly much more to say about how the fight against the rule played out over the last few years. Before we hand it off to him, though, a brief word from Overdrive Radio's sponsors.
Synchrony Car Care is a robust program built for your business and your customers. We offer drivers a way to pay for the services and parts they need today, but there's so much more to Synchrony Car Care. We treat your customers as an extension of your brand, and we don't take it lightly. We're committed to a simple application and fair terms. Let us help drive traffic and drive success for your business.
First Guard provides commercial truck insurance to leased owner-operators done right, as we've done for more than 80 years. We provide physical damage and non-trucking. Many companies make you pay up to 6 months of insurance premiums up front, but not First Guard. We bill monthly, so you get quality insurance without needing to pay a lot of cash up front. Go to firstguard.com. That's 1stguard.com. First Guard. We speak trucker. Let's talk.
How did we get here? The thing I would let everybody know, and I'm used to talking to folks not only in California but around the country, this actually started through a California Supreme Court decision back in 2018 on a case called Dynamics. And in that particular case, that's a small package parcel delivery company, and the case involved whether the workers were being classified properly as independent contractors. So in the course of the Supreme Court rendering a decision in that case, they actually created this, what is now the AB5 ABC test, the formula, if you will, to classify workers, whether they should be classified as independent contractors or employees. So at the time of that decision in the spring of 2018, by the California Supreme Court, that actually became the law of the land, this onerous ABC test that we're facing right now. So fast forward into 2019, the California State Legislature went ahead and took care of Assembly Bill 5, AB5, to basically codify that California Supreme Court decision. They went ahead and broadened the scope of how AB5 and this ABC test would work. But in doing so, they basically formalized that and put it into law. So the California Trucking Association, we actually filed litigation against this ABC test early on, back in the fall of 2018. So even prior to AB5 coming into play the following year, we had already filed suit. So as those deliberations went on during the course of 2019, we were advocating, lobbying against AB5 itself. The one thing I would share with this group, when you looked at the hundreds of industries, and professions impacted by AB5 and taking away that ability for people to independently contract with businesses and others, I would tell you this, for all of those different classifications and categories and jobs and such, there was no stronger voice, there was not a more impassioned voice than from independent owner-operators. So when you'd be at the state capitol for these legislative hearings about AB5, you would have a bunch of different industries. You'd have real estate, think about anybody who does independent contracting. It hit everybody, but there were no larger group than independent owner-operators who traveled to Sacramento, came to those hearings, told their personal stories about why they wanted to continue to be able to independently operate and not be shoved into an employee status mode.
You heard Yadon commenting to me on this phenomenon during my brief talk with him after the presentation and panel discussion you're hearing now. You heard some of this up top, but here's a little more of what he told me about the grassroots swell of advocacy in Sacramento around AB5 during that time.
I think what occurred was, as we were communicating outward really to the whole trucking industry, the whole trucking community, about the impacts of AB5 on independent owner-operators, that groundswell of education really started to hit individuals. And so then those discussions continued back and forth between our team and the independent owner operators. And those folks made it very clear, we need to tell our story. So they would drop what they were doing. We knew they were coming off the road, from their own business to make their voices heard in Sacramento. And I would characterize it as probably 95% of the voices at legislative hearings and individuals testifying. Probably 95% of those individuals were from trucking, were the independent owner operators.
And Yadon continued with the story during the presentation.
And even with all of that happening, literally over 100 professions and industries were carved out of AB5, but trucking remained in the bill, as did the gig economy and several others. But just to let the folks know that the drivers out there, the professional truck drivers, we all know they want to be able to operate independently. That's their choice, right? When you talk to folks, so many of them, well more than half, the lion's share of drivers out there, independent drivers, have been employees in the past. So they've done that. They love operating independently. We're out there trying to protect that. So to fast forward where we're at today, we went ahead, we were able to amend our litigation after the passage of AB5. So we continued that legal challenge to AB5 under the California Trucking Association, and a couple of independent owner operators are also listed as the main plaintiffs. We were very fortunate to have a preliminary injunction granted at the U.S. District Court level at the very beginning of the year 2020. That preliminary injunction has stayed in place all the way through today. And that basically prohibits the state of California from enforcing AB5. So we're allowed to continue to see independent contracting, independent owner operators operating in California. We all know it's a very confusing time because this court case, we don't know what direction it can possibly go. Greg will get into that, I'm sure, as to all of the what ifs of what might be happening. So we've had a lot of twists and turns in our legal challenge. The most recent, we're sitting here on Thursday morning. We filed our petition for cert before the United States Supreme Court late Monday. So we're here just a couple of days after we put in our petition with the United States Supreme Court, and we're asking the U.S. Supreme Court to take up this case. And we're asking them to answer that question, hopefully once and for all. Does the Federal Aviation Administration Authorization Act, it's also known as the F4A, does that preempt this type of an ABC test? We feel very strongly that we are protected by federal preemption and that a state statute like AB5 is preempted and should not apply to the trucking industry. And we can go into more details as to why that's the case, or maybe not, but the point is, the question now is before the U.S. Supreme Court, and we're very hopeful, as tough as those odds can be, of the U.S. Supreme Court accepting that petition and saying, yes, we will review this. Our hope, because this is of such national significance to this industry and to those owner-operators, independent business owners out there, we feel this question needs to be resolved once and for all. And so our hopes are kind of pinned on that right now. There are other avenues down road, but for now, the fact that we have this preliminary injunction, this protection in place, it will remain in place until we hear back from the Supreme Court. If they decide to hear this case, and Greg will probably get into details of the timing, then we feel very good. We feel very good about our chances, but we don't know whether that decision will be in our favor as to whether the Supreme Court will take us up. So it's kind of a waiting game right now. And again, a lot at stake, not just in California, but really across the country based on how this plays out.
The next voice you'll hear is that of Jason Cannon, my colleague over at CCJ, where he's editor. He's pitching to transportation attorney Greg Fury, whom you also heard a bit from at the top of the podcast.
Well, I guess, Greg, to speak to the timing question, any idea what sort of time frame for the Supreme Court? Obviously that we're looking at, I guess, a couple of different time frames when they decide they'll hear it and then once they actually hear it. So you have any sort of I guess maybe averages of how long something like that might take?
You're probably looking at 4 to 6 months before the cert petition is reviewed and either taken up by the Supreme Court or not. If we assume that the Supreme Court will hear the case, you're probably then another year out, maybe longer, till you actually have a decision from the Supreme Court. So you're about a year and a half away, if we're lucky, a year and a half away from a decision.
What are the implications that if they agree with the state of California? Because it sounds pretty clear cut and dry that you can't be an owner operator in the state of California, right?
Yeah, Jason, I'll back up and explain what the ABC test is.
Sure.
And kind of how this fire was lit. The ABC test it has 3 factors or 3 prongs, but it is not a multi-factor test. A multi-factor test is various factors that a court would weigh and almost determine how many factors support independent contractor status and how many support employee status. And if a majority of the factors support independent contractor status, then the worker's an independent contractor. The ABC test is the plaintiff's opportunity, the person trying to prove that they're an employee, their opportunity to have 3 bites at the apple to make that happen. And what's more difficult, they don't have to prove it, it's the company, the motor carrier in our case, has to show that the worker is an independent contractor. They have to show, A, that there is no detailed control over the owner-operator's work. I'm going to go to C. C, that that owner-operator independently established their business. The way that's usually shown is that the business would continue even if the independent contractor no longer provided services to the motor carrier. But the B prong I saved till last because it's the highest hurdle. The motor carrier has to prove that the owner-operator is not in the same trade, profession, or occupation as the motor carrier.
As most of you know, if you've followed this issue at all over the last few years and Overdrive's extensive reporting on it, the ABC test isn't a 3 strikes and you're out kind of thing, to use the baseball analogy. Rather, it's 1 strike and you're out. Fail to satisfy even the problematic B portion of that test, difficult for carriers with traditional federally recognized exclusive lease contracts with owner-operators, and the owner is contracted no more. There's one exception that Fury knows of, though, and he describes case law here.
Now, there is an Indiana Supreme Court case that actually does hold under that ABC test that an owner-operator is an independent contractor, but it's the Indiana Supreme Court, so it's an important court. But it's somewhat of an outlier decision because you have to get a judge, and in this case, left-leaning judges that aren't predisposed to actually leaning in favor of these arguments in the first instance. You have to explain to them that being a motor carrier is very different than being an owner-operator. Now, the people in this room, Jason, they know the difference. But judges are so far inclined to look at it as trucking is trucking is trucking. You're both in trucking. You're both in the same trade, occupation, or profession. Game over. Even if you've proved the A prong and the C prong, you haven't proved the B prong. The Teamsters have been in favor of this test for a very long time. But if I were to, and I got to take a step back for just a second and tell you this, because he won't. Shawn Yadon, I've known him for a long time. He's among the best executives in the state trucking associations. If this is going to happening in a state like California or even Alabama, but in California, he's fighting the battle for the entire country, and his leadership has been really, really critical to us getting to a point where it looks like we should win this battle. But trying to marshal everybody in and the money, what is it, $2 million?
Yep.
To go to the Supreme Court I'm sure everybody can appreciate the costs associated with that, and getting, $5,000 and $10,000 and $15,000 and maybe $1,000 and maybe $500 in to make that happen. So Shawn really, we owe him a debt of gratitude, regardless of how this falls. But anyways, let me go back to something that probably people remember. There was a USA Today series of articles. There were 3 articles called Rigged. And some of you may recall them, some may not, but it was written by a young reporter from Berkeley who had written his senior thesis on indentured servitude in America, slavery basically. And he effectively said that that's what's going on in the ports of LA and Long Beach, was motor carriers taking advantage of owner-operators and casting them into slavery. They hardly make any money at all. They force them to buy those trucks, and then they don't pay them. And while I won't deny that that situation has occurred and probably still does occur, the rank and file in the trucking industry don't do that. Matter of fact, just the opposite. Shawn commissions a study where the owner-operators are making somewhere around 10% to 15% more than a company driver. Now, these guys that are working hard and building their own businesses are actually making a lot of money. But here's what's interesting about that article. Came out, it's front page news for the US Today over about I think a 2-month period. Justice Ginsburg in an American Trucking Association argument at the U.S. Supreme Court at one point asks the lawyer arguing that case, and it had to do with independent contractor status, she says, "But sir, in all due respect, isn't this whole system rigged?" And it was shortly after the USA Today series of articles had come out, literally influencing, at least one would think, a Supreme Court justice. You've seen laws passed in the state of California with their preambles making reference to a journal article, and not it's a USA Today piece. It wasn't particularly well researched, and it was certainly quite biased. That leads you to some high-profile cases in California, and ultimately to Dynamics, really a case with some bad facts, to be honest. And now here we are on April 28th, when a 3-judge panel at the Ninth Circuit rules on, at that time, a case called CTA versus Becerra. That was Shawn's challenge to the California AB 5. And the court basically ruled against keeping a preliminary injunction in place. It had come up from a lower district court that said, the federal district judge said, "I think the likelihood of federal preemption to stop this law from applying to the trucking industry is very high. I'm enjoining this law from being applied to trucking in California." The Ninth Circuit says, no, this is a law of general applicability. This AB 5 is not a law that was ever intended to directly regulate trucking. It regulates all of the industries in California. Now, I find that interesting because you have 2 choices in passing a law, in enacting a law or writing a law. You can either have it apply to everyone and then exempt out travel agents, insurance agents, doctors, lawyers, architects, CPAs, engineers, commercial fishermen, newspaper distribution, newspaper carrying, photographers, professional services of all kind, IRS contractors, freelance writers, licensed cosmetologists, financial advisors, realtors, and repro men, to name a few. That's just a short list of a very long list. You can pass a law and say it applies to everybody except almost everybody. And then when you do that, you have a law of general applicability. You've passed a law that is not directed to the trucking industry. You've passed a law that applies to everybody except for everybody but the trucking industry and a few more industries. So they certainly understood where the Ninth Circuit was going to come out on this when they even wrote the law. And the Ninth Circuit has had a history of being very obviously activist. I can't now remember the justice that said this. There was an appeal to the Ninth Circuit, and the justice says, this case comes to us from the Ninth Circuit, but there's even better reasons to reject this case. So it's had a long history of activism, and there is a case that Shawn's attorneys are relying on. It's Ginsburg versus Northwest Airlines, where the court basically says it doesn't have to be a law that's directly regulating the trucking industry or to be preempted by the F-Quad A or the F4A. So where we sit today is, and Jason, you and I talked earlier, the ruling isn't directly about independent contractor status. It's that is a byproduct of this ruling. The question really is this: can a state law impact prices, routes, and services of motor carriers? And it's a question not only of state rights, but it's also a question that involves justices that want to protect business. We think it will, if they take the case, it will fall in our favor. Will they or will they not take the case? It has a couple of pretty important parts of the recipe. It has to be an important question, it has to be a federal question, and there has to be a split of circuits before the Supreme Court will typically take a case. But now, because so much goes up to the Supreme Court, about 2,000 petitions every session, and they take about 90 cases out of those 2,000. It really has to be a deep split in the circuits, and we have that here too. We have the First Circuit that said a similar test in Massachusetts was preempted. And we have the Third and Seventh Circuit, though, while they did not uphold F-Quad A preemption, the reasoning was consistent with our arguments in, now it's called CTA versus Bonta, because Becerra was the Attorney General at the time the case was filed, and then Bonta was put in place as the Attorney General. So, sorry for I'm not even sure I answered the question you first asked. I did what an attorney did, was kind of redirect it into something I can talk to, but that's all right. But that's kind of where we're at. If the case is not taken by the Supreme Court, you can expect left-leaning states, such as not Massachusetts because it's preempted there, New Jersey, Washington, Illinois, Colorado. I think Alabama is safe. Alabama has a statute that deems owner-operators to be independent contractors, but you're going to see some of the blue states take this ABC test and apply it, and we will be dealing with almost two different laws applying to the same person, depending on where they're driving. Sometimes they're going to be independent contractors, sometimes they're going to be employees. It's really a patchwork quilt and kind of a mess if it goes that direction.
So that would set up a scenario to where business conditions in one state, you've got an owner operator that's contracted to haul, but if they drive through a state to where you can't use an owner operator, I mean that's going to kind of reinvent your entire business model there. You may have to dodge an entire state.
That's the argument that won the day in Massachusetts Delivery Association versus Coakley. That's the First Circuit. And that's effectively what they said is, wait a minute, you've got a guy that's entered into a contract in the state of Virginia where he has acknowledged that he's an independent contractor, he's got his own business, but if he delivers into the state of Massachusetts, as soon as he crosses the state border, he's an employee and he's entitled to all these employment rights, but he's in effect, he's lost his business. At the moment he crosses into Massachusetts, he becomes the employee of the motor carrier. And Shawn's point is really the compelling point to all of this. It's not hard to find. Well, let me give you an anecdote. Big motor carrier, you guys all know this. This is public information. Intermodal carrier called Hub Group. Class action in Los Angeles, and their determination was that they were going to settle this case and move on. And they frankly weren't even going to use owner-operators anymore. They could see the writing on the walls. Too much litigation, too much cost. We're just going to turn to a company driver fleet. And they sat down and offered all their owner-operators a deal. They bought their trucks. They gave them a signing bonus. They became employees of the company. And that was great for about a month. And within 3 to 6 months, there was, something less than 100 of those several hundred owner-operators that even stayed as company drivers. They don't want to be company drivers. There's an opportunity, what's the statistic, Shawn? 10 to 1? That if I'm an owner-operator and I want to be an employee driver, I have 10 opportunities to every 1 opportunity to be an owner-operator to be a company driver. Yeah. If I wanted to do that, it wouldn't be that hard to do. Yeah. And the owner-operators are very much in favor of, they didn't get pushed into being independent entrepreneurs. They chose that as what they wanted to do, build a business. So it's, I don't want to be too controversial, but it really feels very anti-American when you look at what's going on here. It's really paternalism, protectionism. The state of California feeling as though the issue of wage and wage protection is the most significant social welfare benefit in the state, and they want to pass a law that makes it very, very difficult for anyone to be an independent contractor. And in dynamics, the California Supreme Court put it all out there just that way. They didn't try to hide that agenda. That was their stated agenda.
I guess my next question is, the Supreme Court ruling, whichever way it goes, does that set any sort of precedent for any other state? That can you challenge, like you use Alabama as an example, could I challenge Alabama's standing and point to the Supreme Court's ruling as something that should supersede it?
Well, what the Supreme Court's going to rule is that in this instance, this law either is preempted by the federal by a federal law, or it is not. So versus saying, hey, these types of workers are independent contractors, that's not, even though that's the byproduct of the decision, that's not the decision. So issues of federal preemption do come up across the country from time to time, but I don't know that will necessarily change if you're an Alabama motor carrier operating in the South and Southeast. Most of the laws in the South and Southeast, with some North Carolina being a bit of an outlier in that regard, most of the laws support independent contractor status for owner-operators. So I don't know that you're necessarily going to run into it until you go up to the New England states or Illinois or out to the West. Once you do that, you're likely, if the Supreme Court doesn't take this case or rules against us, then you'd likely have to change your business model in those states.
One of our text questions is, does Pennsylvania or New York have any protection?
Pennsylvania has a case called Universal AmCan, which was decided in 2000 by the Pennsylvania Supreme Court, that's very strongly in support of independent contractor status. The state of New York passed a law in 2014 called the New York Fair Play Act. And while New York certainly is a left-leaning state, I'm not sure the legislature will jump on AB5 because they just passed this New York Fair Play Act. I know it was in 2014, but Shawn can tell you that's still pretty recent, right, that the legislature wouldn't probably touch that. That's not an easy law to pass, but it is a multi-factor law, the New York Fair Play Act.
Next question, and I get maybe for both of you guys. It's you seem to have a lot of confidence that the Supreme Court will hear the case and that CTA is on the right side of it. What gives you that confidence?
Yeah, I don't know. I don't know if I'd say confidence that they'll take it up. Greg correctly outlined the historical, just the numbers game, right, of how many petitions come to the U.S. Supreme Court. So in terms of a hill, that's a steep hill to climb. But I would say I feel really good about the filing that we put forth and how we've posed that question and very clearly articulated that deep circuit split that Greg said is really one of the criteria that we hope that the U.S. Supreme Court would take a look at. If you think about it, if you have a circuit split with the First Circuit ruling one way and the Ninth, and Greg mentioned a couple of the other circuits, but when you have that type of a split, I mean, where else can you go to get that rectified but the U.S. Supreme Court? So if you look at, perhaps one of their big purposes would be to be that final decision maker on something like this. So I guess the way I would say it is not as much confident that will be taken up. Our huge hope is that we will, but more along the lines of if we are heard by the Supreme Court and they take us up, then we feel good about our chances at that point. So really that's the steep hill right now, is getting through that clutter, if you will, of all of those other petitions that are on their way or already sitting in front of the Supreme Court right now.
If you think about it, it's difficult to sit here and say, I think they're going to take the case. If you had a bunch of hanging chads and what was in the balance was who's going to be the president, I think you're pretty confident the Supreme Court's going to address that case. In this case, it's really difficult to be confident that will occur, in part because some of what the Supreme Court is weighing is what are all the other cases that we're being asked to address. And if they only address 90 to maybe 100 in a session, and there's 100 more compelling issues than this issue, you're out of luck.
Another text question. If an independent contractor gets their own authority, how does that impact leased and brokered loads based on current contract language?
I like that case, right? If you're a motor carrier and you're doing business with an owner-operator under a conventional independent contractor agreement where they're operating under your authority, that model is really challenged by AB 5. The flip side of that presumably is this, that instead of being a motor carrier, you broker the freight to that same owner-operator who's gone out and got their own motor carrier. Now the legal argument is, under the B prong, remember that's the one we're worried about, Judge, I'm in a different trade profession or occupation from the owner-operator who's a motor carrier. First of all, the motor carrier has a lot more and different regulations that they have to operate under. They have a completely different authority. I'm a broker. I actually can't move freight physically from point A to point B under a broker authority. It has to be a motor carrier authority, and a motor carrier can't broker freight under motor carrier authority. So there's some pretty compelling, albeit maybe a little technical, arguments to say property brokerage is a different trade occupation or profession from motor carriage. No one here would argue that C.H. Robinson is in the same business as Landstar. They are all in the general rubric of being in the trucking industry for sure, but not in the same trade occupation or profession. So I like that argument. We'll see if we have to make it, and we'll see how the, again, left-leaning judges accept or reject that argument.
This may be our last question, but it's, is there anything we can do proactively ahead of the court's decision? And maybe this would be specific to carriers who are not in the state of California. Should everybody be reevaluating their independent contractor contracts? Should they be reaching out to their local representation? Is there anything anybody can do?
Well, I think you're always, I'm not going to sit up here and say, hey, no worries, don't do anything. If you're a regional operator in Alabama, Georgia, Florida, Louisiana, I'm not sure I'd be pressing the panic button or really thinking, I got to change my model and I got to do it now, because the upheaval of that could cost you more than what might happen in the next 5 to 10 years. On the flip side, if you're dependent on operating to, through, or from certain of these blue states or left-leaning states, I think you really have to seriously think, can I pivot to a brokerage model where my owner-operators are motor carriers? Can I change to an employment model in those states? There's 4 or 5 strategies. There's a strategy called the 2-check system. There's some things that you at least want to explore, and remember, anything that you do first starts with the customer, right? So if you decide, well, I think I will be a property broker and tender to authorized motor carriers that used to be my owner operators, you got to go back to your customer and say, can I sign a shipper contract that makes me a broker and not a motor carrier? So some of that exploration is just kind of socializing the idea of changing your model with the shipping public.
No doubt plenty to think about there. Overdrive Radio is a production of Overdrive, the voice of the American trucker. It's edited and produced by me, Todd Dills, with additional support from Overdrive Extra contributing writer Paul Moorhofer, Overdrive news editor Matt Cole, social media coordinator Holly Young, and executive editor Alex Lockey. Until next time, keep it pro out there.